United States? And then lastly, under what circumstances, if any, might the writ of habeas corpus place an unreasonable burden on the government? Whenever you're ready.
Latin for you have the body, a writ of habeas corpus requires the government prove its detention of an individual is lawful by delivering the accused to a judge for such determination. Historically, however, the writ was primarily used by those in prison without judicial process. Early Americans were keenly aware that monarchs of England had sometimes jailed people indefinitely without charging or trying them in court, and despite the existence of the writ of habeas, the king often just ignored it. The founding generation valued the Great Writ because they had this history in mind. Thomas Jefferson called the protections provided by habeas corpus one of the essential principles of our government. And in 1789, James Madison argued for the adoption of the Bill of Rights, including habeas corpus. Along with this, one of our most notable founding fathers, Alexander Hamilton, thought that its inclusion brought with it protection of our most fundamental rights and stated that the habeas corpus clause was the primary defense against arbitrary arrests and imprisonments. The biggest responsibility of a government is to protect its people's rights, and when a person is arrested, they are quite literally denied access to life, liberty, and the pursuit of happiness. The enumeration of habeas corpus within our Constitution ensures that these natural rights are not taken away from us without due process or reason. In this sense, habeas corpus is essential to the principle of limited government and our country's system of checks and balances.
The principle of habeas corpus is one of the essential ideas that our nation was founded on and acts as a cornerstone of limited government. The writ itself has remained the same since its creation. However, the way it's applied by our government officials evolves as our society does. As new amendments and laws are created, the application used 100 years ago might not accurately fit the situation today. For example, in 1861, John Meridian was imprisoned under suspicions of supporting Confederate activities. A general at the base where the incident took place claimed that because President Lincoln suspended habeas corpus, the arrest was legal. Well, Justice Taney submitted an opinion on the writ of Article 1, Section 9, with the belief that the president did not have the power to suspend habeas corpus, rather it was up to Congress. Another important habeas corpus case was Gideon v. Wainwright in 1963. Clarence Gideon was charged with a felony for breaking and entering and proceeded to appear in court without a lawyer. At the time, Florida laws only appointed lawyers to indigent defendants in capital cases. Since this was not a capital case, they did not provide him with a lawyer. He was forced to act as his own lawyer. He was found guilty and sentenced to 5 years in prison. Gideon appealed to the Supreme Court and they voted 7-2 in favor of Gideon and cited the Sixth Amendment's right to counsel applies in all criminal cases. Since the writ of habeas corpus is so vague, we see new challenges arise as our society evolves. In these court cases, we see different issues and conflicts over the application of habeas corpus. There's a constant battle over what is protected and what is not, and over time we see changes of its application depending on political leaders and societal changes.
While a writ of habeas corpus is essential in protecting the rights of individuals and limiting governmental power, it can hinder the government's ability to ensure public safety. The founding fathers were conscious of this dilemma, and in Article 1, Section 3, they outlined that habeas corpus may be suspended in cases of rebellion or invasion if necessary to ensure public safety. Under these conditions, habeas corpus has generally been suspended 4 times within our history. During the Civil War, during the Reconstruction period, and in the Philippines in the early 1900s, and during World War II. However, we recognize the importance of habeas corpus in limiting governmental power. If left unchecked, the overreach of governmental power can have disastrous effects, the greatest example of which is exhibited during World War II with the internment of American citizens. With the fear of foreign espionage, President Roosevelt signed Executive Order 9066 and was reinforced by Congress by passing Public Law 77-503, which allowed over 100,000 Japanese Americans to be relocated to internment camps. Despite an attempt to reverse this practice in Korematsu versus the United States, the Supreme Court ruled in favor of maintaining these internment practices, without habeas corpus, tens of thousands of people deprived of life, liberty, and property. We recognize that habeas corpus burdens the government during strenuous times when swift action is necessary, especially during times of war. However, as a society and as this writ continues to evolve, habeas corpus should always be present since it's a necessary cornerstone for limited government.
All right, perfect timing there, nicely done. So I'll start off with I want to just ask you to elaborate a little. You touched on the evolution, of course, kind of ran that down in your essay nicely. You talked about that it's largely the same, but its application has changed over time. And the circumstances, the reason it changes is because circumstances change. What's your understanding of how states have applied it, or does it apply to the states? So you have federal law, you have state law. If you break a state law, you're dealt with in state courts, not federal courts. So what's the relationship between the writ and states?
Yeah, so I would say we see this most commonly in modern times, is a lot of times people are convicted of a crime at a state level, and they will use habeas corpus to appeal to the federal level to try to get retried. Usually this is because they feel that the state was biased against them and that they're innocent of a crime. And we've seen this especially with death row inmates. And it kind of echoes the history of habeas corpus back in the 1600s in British Parliament, when it was used by lower courts to try to gain advantage on higher courts, and then evolved to higher courts trying to get advantage on lower courts. And it's been something that's been contested a lot, but that's how I would see it relating to states, is a person's ability to contest what they've been tried for at a state level to the federal government.
Very good. Thank you.
Okay, let's talk about the suspension clause, right? It's got the necessary vehicle for us to suspend habeas corpus at a time of rebellion or when the public safety demands it. Is that language appropriate today? In other words, is it too vague? Do we need to shore that up? And do you see any potential violations of that in the modern setting?
I guess from my perspective, at least, I think that the founding fathers had a good reason to keep it vague, so that as we mentioned, how society evolves, how the way we interpret our laws evolve, we can interpret this vague statement into what's more adequate and what's more beneficial to our current time. So I think a modern example that we kind of run into, kind of how vague this statement is with the Capitol insurrectionists. Maybe that could be classified as a rebellion, depending on what perspective you take. And of course, as far as I'm aware, we haven't, restricted habeas corpus for those individuals, but I think depending on where you are, you can utilize the vague understanding, the vague phrases of this restriction in the Constitution to kind of levy that against those insurrectionists to kind of make sure they have consequences for their actions.
Is it
I'll jump
possible?
in real quick, just building off Xavier a little bit. I do agree, like the vagueness of this statement puts a lot of pressure, as we kind of talked about at the end there, a lot of pressure on those in charge, because everyone's going to interpret, threat against society or our country differently. And I think that's, as you mentioned with the Capitol insurrectionists, like it all depends on who's in charge. And, again, with the person, the president versus Congress, as we kind of touched on a little bit in the middle, you got to have a bipartisan group of people discussing that rather than just one, person. I think that's where you can get into some of that more tyrannical things, when one person is making that decision rather than having, a group of people sit down and discuss that.
I think along with that, the vague wording of the habeas corpus or the suspension clause, it leads to a lot of problems in which like who should be able to suspend habeas corpus. And we've seen that contested time and time again. For example, when Lincoln used the suspension clause and he had to go to court and they ruled against him, but then Congress ended up suspending it anyways for him. And there's also been times like during the executive order 9066, I believe that Governor Warren from California, he also enacted the suspension clause. So it's I think it would benefit us if we were to make it more concise and clear about exactly who has the power to enact the suspension clause. It seems as though the founders wanted it to be Congress, since it's under the first article and it talks about the rights that Congress has. But obviously we've seen precedent for other people being able to suspend it or not suspend it. So I think we would benefit from some clearer, more concise language in that sense.
Thank you.
I think we could benefit from more clarity on a lot of things. This is a really ambiguous, tough topic. And I think it gets at, like, even setting aside the topic of habeas corpus, if we just think more broadly about this tension between civil liberties, individual rights, and public safety and the public good. Are there other issues or topics that come to mind, or historic examples that might come to mind of a time when civil liberties were set aside or suspended for the sake of the public good? And do you think those were justified?
To that, what comes to mind, at least for me, is what happened in the Philippines when we went and helped liberate the Philippine islands from Spanish Inquisition. And then we decided not to leave. And that led to the people of the Philippines revolting against us. And we decided to enact the suspension clause then. And I feel personally, I'm someone who really totes human rights. And I think when the founders wrote the Constitution, they wrote it for the American people, but they don't say they don't say the American people, they say all men are created equal, all men. And so I think in those cases, you know, we should be uplifting those rights and those beliefs that the founders had and apply that to everyone. And so when we look at what happened in the Philippines, I find that like a debasement of habeas corpus and an abuse of it, honestly.
I'm going to jump in and take this a little bit a different direction than she went with the battle between public safety and civil liberties. I think we see that really evident today with COVID-19. We have people saying this is this is my right. I don't have to go out inside and wear a mask, when that's putting, the entire, world, our communities at risk. And that's a constant battle where you don't know, can you make people wear a mask for the, public safety? And same thing with vaccinations. Are we required, can we mandate that, or is that infringing on their civil liberties? I don't know that there's a clear answer for that. But that's just a time evident in today.
Absolutely. Yeah. Thank you.
Okay, nicely done, Xavier, Colette, and Noah. Yeah, it was fun, and maybe it wouldn't be your classification of fun, but we enjoyed it, getting to listen to you as well as pick your brains along these lines, and you're well versed in it. Your breadth of knowledge is apparent. I enjoyed or appreciated, was impressed by some of the kind of the wide-ranging references from toward the end, the reference in the Philippines, of course, January 6th issues, pandemic issues, from Lincoln and Chief Justice Taney, and states issues around death row. I think they are predominantly or take up the bulk of state writ issues, or certainly a dominant part of it. References to Gideon, that leads to Miranda. So you covered that nicely, and as the other judges have pointed out and the questions indicate, I mean, it's an evolving area, and it kind of ebbs and flows and goes up and down, and the war on terror has been its newest iteration of complications. And so you can continue to the extent you want to, and down the road when you're in college or university somewhere, you may be able to draw upon it and you can pull further from it. But anyway, well done, and it was enjoyable to listen to you. Wish you well.
Yeah, I concur with what Steve said. I really appreciated your opening response. You tracked the question. You gave us signposts to tell us where you were. You gave us examples. You gave us support to your arguments. You didn't just give us opinions. You gave us arguments, and that's what this is all about. A well-structured argument with evidence and support and rational explanation, and we appreciate that very much. I like, I just want to say sometimes civic education and classes are sort of criticized for being like, like blind patriotism and love America. And we do love our country, but you can critique your country, right? And that's how we get better. And I like that, you're able to say, in Colette, it was like, it's a debasement and an abuse of habeas corpus. Our country did that. And it's okay to say that, because if we don't acknowledge what we've done possibly wrong in the past, we'll never get better. And that just is refreshing to me, to know that you're willing to be critical but not destructive, right? You're going to be critical. You're going to build us a better country someday. And what I hope you can think about more is the riskiness of words, right? Language is brutal, because what one person says is a rebellion is really just a way to suppress dissent. And what I was thinking about was the different treatments of the BLM and social justice movements and the January 6th events. Wow. That, to me, that needs some serious discussion as a country. I don't know what the right answer is for any sense, but I think you all were going to figure that out someday. So I wish you all the very best of luck. Congratulations, Coach. You did a great job.
I go last, so I just repeat everything that's already been said. So I asked at the end about this tension between civil liberties and public safety, and we went from the Philippines to present day in COVID. So I think that sort of broad sweep was evident in the entire presentation and back and forth that we have. The only other thing that I would, again, incorporating all of the other praise, the only other thing I would say here is that this whole civics competition would be really boring, and I wouldn't be a judge if the questions were like, what year was the Constitution, and what amendment was this? That's just rote memorization. No one cares about that. You could train, well, you probably can't train a dog to do that, but you could do that stuff in 4th grade, and it's not a big deal. But what makes this interesting is these questions that draw on really mushy and difficult and messy concepts that can be argued both ways. To do that competition well, you don't need a good memory. You need critical thinking skills, and you need to show that like you've done your homework and you've thought about it, and you've like broken it down and you put it back together in different ways, and somewhere in there comes an original thought. That's why I like doing this, and that was very evident in both your presentation and then the back and forth you had with us in the Q&A section. So I appreciate that. Thank you very much.
Way to go, group, and thanks and congrats again to your teachers. So all the best.
Thank you so much, judges. I really appreciate it.